This video is about the two different types of courts. We have trial courts and we have appellate courts. So each system is divided into these two distinct sets. Our trial courts are the courts with original jurisdiction. They hear the case first. And the appellate courts are the courts with review jurisdiction or appellate jurisdiction. They're going to review what happened in the trial court. So let's break this down a little bit more. So trial courts, they hear the facts, they hear the law, they hear it all. This is where the person who wants to do the suing or the government who wants to prosecute has to take their case to a trial court, the court of original jurisdiction. So the facts are what happened. This is what happened in the case. Witnesses come in, documents for evidence comes in. If it's a criminal case, there might be some other sort of, maybe video, audio. That can also be in civil cases too. We'll talk about the difference between civil and criminal cases. But basically, everything that is relevant to the circumstances will come in at this particular point at the trial court. There's also sometimes legal issues that come up. Someone might want to put some certain type of evidence in the case and a party's going to object, saying, hey, that's not related to what we have going on here. And the judge has to make a decision. Whenever the judge has to make a decision, it's making a determination on law. Will the law allow that particular thing to happen? So everything is happening in this trial court. We're hearing all the facts, and the judge is making rulings regarding the law and the legal proceeding. That's procedures that are happening in that court. So that's what happens in the trial court. And all of this is going on, and if you've ever been in court or seen a court TV show, there's a person that kind of sits in front of the judge's bench taking everything down, the transcriptionist, the court reporter, whatever. I call them the court reporter. Some people call them a transcriptionist. They're taking down everything that's happening in the court, and they're creating what's called a factual record of the case. Now, the loser at trial court, and both parties think that they could be a loser, depending on what kind of case it is, can ask an appellate court, the next level up, or the review court, to review the case. The appellate court doesn't rehash it, or let's have a new trial, let's bring everything in. No, that's not what the appellate court is about. The appellate court takes that record that the court reporter created from the lower court and reviews that information, but also they just don't say, hey, I'm just going to check this case out. One of the parties has to bring it to appellate court, and they have to raise issues. The only issues that the person, the loser, or the one who wants the appellate court review can raise are questions related to the judge's determination on the legal issues. If we're talking about a case that had a jury and the jury has made a ruling, the appellate court doesn't look at the record and say, yeah, the jury got that completely wrong. This is what we're going to do. No, that's not what the appellate court does. The appellate court looks at the rulings of the court that are raised by the parties and says, you know what? The judge got that answer, the answer to that question of law wrong. And because that judge got the answer wrong, this would have been heard by the jury, or this would not have been heard by the jury. And that may have changed the decision or their decision. So now we're going to make some changes. That's generally what the appellate court is looking for. They're reviewing what the judge did, the rulings, the decisions that the judge made requiring the case. And depending on how serious that error was, will determine whether or not the appellate court will overturn the decision and send it back for a new trial or make some other changes, depending on what the issue is. It could be an issue regarding damages. The plaintiff may have wanted $1 million and the jury awarded $10,000, and that wasn't what they wanted, so they would have, have that reviewed if any decisions were relative to to the court ruling on that, because the lower court in a damages would have to confirm the amount. So that would be the error that would be raised, because the plaintiff wanted more money, and the appellate court can change that higher or lower, one way or the other. So that is what they do. They determine whether or not there's errors. If there's no errors, the decision stands. So, but if the appellate court deems that there was an error, depending on the error, they can order a new trial, dismiss the case, or change the damages. That's pretty much what an appellate court can do. So let's look at how the court system is structured, and we're going to start with the federal court. Like I said, each of the 50 states and DC have a federal court system with a lower court and an appellate court, and it's structured a little like this. I got a better slide on the other side diagram, but I'm going to use this for a minute. The district court is the lower court. They call them district courts. That's our court with original jurisdiction. The lower court, the trial court. Some states have more than one of these. New York is one of them. We're a big state, so we have 4 district courts. We have the Northern District Court, which is where anybody, Albany, actually Binghamton and North, and over to Syracuse. That is the Northern District of New York. We have the Western, which is Buffalo, Rochester, out that way. And we have the Eastern and the Southern districts. So we have 4 districts in New York. And then the loser in the district court gets to appeal up to the U.S. Court of Appeals. That will hear any sort of issues relative to the case. And because we have the United States Supreme Court as the Supreme Court in the land, they could hear an appeal. This is a direct from district court to the U.S. Court of Appeals is a direct appeal. The loser gets it by right. There's no asking for it. It's an entitlement by right. However, if they want the Supreme Court to hear their case after not being successful in the U.S. Court of Appeals, they have to ask for permission for the United States Supreme Court to take the case. And as you can imagine, there's lots and lots of requests, about 7,000 a year. The U.S. Supreme Court takes about 100 cases, so not many get selected. But nonetheless, it is an option, and this is how the federal court system operates. So the U.S. District Court, there are 94 districts, and each of these districts also has a specialty court, the bankruptcy court, and we're going to explore bankruptcy court a lot in this course. Not a lot, but it is a chapter we're going to spend on. Plus the Court of International Trade and the Court of Federal Claims. We are not going to talk about these specialty courts, but we are going to talk about the bankruptcy court. And then the U.S. Court of Appeals, there are 13 circuits. So not every single state has its very own federal appeals court. The states are lumped together into circuits. And I'm not going to go through each and every one. I'm going to tell you the biggest circuit is the 9th Circuit. It's the largest one. It has California, Hawaii, Alaska, Arizona, and Guam. Those are all of the states, the U.S. district courts in those states. That's their appellate court, the 9th Circuit. The 2nd Circuit is where we find New York, along with Connecticut and Vermont. So Connecticut, Vermont, New York are in the 2nd Circuit. So federal court's jurisdiction. Cases, there's only 7 types of cases that the federal court has jurisdiction over. The ones in bold are the ones that mostly show up in the federal courts. Cases that arise under the U.S. Constitution. So if somebody claims a statute violates the U.S. Constitution, it goes to federal court in that state. So if the state of New York passed a statute, one of our gun laws, for instance, if somebody or some organization wants to challenge that as constitutional, they bring it to the district court in New York. It could be any district court in New York. You can bring a case, but if the organization or the person happens to be in Albany, they're probably going to pick the Northern District of New York because it's obvious, it's a close enough venue, but they can choose any of them. cases involving ambassadors and ministers of foreign countries, cases involving admiralty and maritime law. Number 4 is a big one, cases involving controversies where the United States is a party to the case. And I will tell you, the United States is always, always, always a party to a case in a criminal case. If it's the federal government that does the prosecution of criminal cases, so the United States is always a party. Cases involving controversies between states. So if New York and Vermont have a case that can't be resolved and they have to go to court, it's going to be in a federal court. Cases involving controversies between states. I have number 6 and number 7 together. They should be one of the same. Cases involving controversies between, cases involving controversies between a state and a citizen of another state. So if a Vermonter had issues with the state, want to sue the state of New York, that's going to have to be in a federal court, and probably a federal court in New York State. Number 7, this is the one that we are going to see and use in this course. Cases involving controversies between citizens of different states, and the amount sought is over $75,000. So if, I'm going to use a car accident because probably all familiar with that because we haven't gotten into any actual specific laws yet. But if there was someone from Vermont in Plattsburgh and there was a car accident between a New York State citizen and the Vermont citizen, and there was a serious personal injury, car damage, and medical bills exceeded $100,000, if there was a lawsuit that stemmed from that incident, it would have to be brought in a federal court because it's citizens of 2 different states, and the amount is over $75,000. So those are the primary 7 jurisdiction requirements for federal court jurisdiction, with numbers 1, 4, and 7 being the most commonly common types of cases that are found in federal court. The state court system, as I said, each state has its own court system, and the court is set up different from state to state. There are some similarities. These are the basic similarities. There is a traffic court, municipal court. They hear small claims, usually something involving less than $3,000. Traffic infractions, parking tickets, low-level stuff. Superior Court is the court of original jurisdiction at most state levels. I believe that's the case in Vermont, Massachusetts, Connecticut, not in New York. And I'm going to go through the New York system with you in the next slide. But in New York, our trial lower court is called the Supreme Court. Not to mix it up, but in most court states, it's generally the lower court, of the trial court is the Superior Court. The Supreme Court is what they call their appellate courts. And then the U.S. Supreme Court hangs out there over the top of the state court system as well, because it is the Supreme Court of the land. But they will not hear a case out of state court unless it involves a federal question, something related to federal law. But it's still an avenue and it still can exist. It happens a lot with criminal cases, violation of the U.S. Constitution. So I want to talk about our Superior Court, or Supreme Court if we're in New York State, but our lower trial court, again, it is the court with general jurisdiction, so they can hear anything, and they're the original jurisdiction court, so they're the court to hear the first part of the case, the first case. This is where we find the juries. The juries are usually here. Most civil cases start here, if not all civil cases start in Superior Court. So contract disputes, defamation, real estate transactions gone bad that need resolution, tort cases are things like negligence, prosecutions for violating state statutes, criminal cases can start here. These courts are the ones that get the facts, right, and the law, the record, they establish the record. And then the trier of fact, which could be the jury or it could be a judge, applies the law and determines the outcome. So this is the lower, the trial court. State Supreme or Appellate Court, generally the highest court in the state. It's the final authority on any state law. Does not rehear the case. It only has review jurisdiction, reviews that record from that originating court, and it reviews the law to determine whether or not the facts, reviews the law that was applied to those facts to determine whether or not the judge has erred. And like I said, the U.S. Supreme Court can hear an appeal from this court if there's a federal question. Writ of certiorari or writ of cert is what they will issue when they say, hey, we'll hear this case. So let's talk about New York courts and what it looks like. This is our system here in New York. And right smack dab in the middle is Supreme Court, which is our court of original jurisdiction. This is where any case can be brought. Just to kind of go over this little diagram. New York City Court. New York City has its own civil court, which they hear, this is where they hear small claims. New York City Criminal Court is where they hear small amount traffic court, misdemeanor, low-level criminal cases. District courts are courts on Long Island that hear small claims or low-level criminal cases, traffic court, misdemeanor type cases. City courts, town courts, village courts all hear small claims and low-level traffic offenses and misdemeanor cases. Then we have our specialty or limited jurisdiction courts. Family court, only hear cases regarding family court. Surrogates court hears things about probates and wills and adoptions. County court is a limited court of jurisdiction. So Clinton County, every county in New York State has one. We're in Plattsburgh, so we're in Clinton County. The Clinton County Court only hears felony criminal cases. So every county has a county court which only hears felony criminal cases. Court of Claims is the court if you want to bring a case against the state or any of its agencies. There's a special court for Court of Claims. Supreme Court, like I said, is our original court of jurisdiction. They have general jurisdiction, it's original jurisdiction. This is where a tort case, negligence case, defamation case, even divorce cases come here to Supreme Court. Anything involving a real estate transaction, contract disputes, right here, Supreme Court. Our appellate court is actually called the Appellate Division. We cannot we're such a big state, we cannot have just one appellate court. So we're divided, first, second, third, fourth departments, and it divides up the state. We are in the third department. Albany and North is the third department. And then we do have one more Court of Appeals, and they kind of operate like the U.S. Supreme Court. You don't automatically get to go there. You have to ask for permission, and they will only hear a question of whether or not the New York State Constitution has been violated. That's what they hear, and it's very limited. Again, it's a request. You got to file a request to have a case heard in our Court of Appeals. So New York, and I believe California has a pretty big court system as well. So I have a couple quick jurisdiction examples that I want to go over before we flip to the next video and section. And my first case example, looking at our New York State map here of the court system, contract dispute. We're both in Plattsburgh. You and I, both in Plattsburgh. We make a handshake deal to buy my used car. I have a used car, sell it to you for $5,000. Today you bought the used car from me, and you gave me $5,000. You drive off. The next day it breaks down. You come to me, you want your money back. And I say, too bad. You have to sue me. So you do. And my question is, what court has original jurisdiction? So where does this case happen? You want to sue me? Where are you going? And I hope you're pointing at Supreme Court, right? Dead center. That's exactly where you have to go. My next case example, contract dispute. We have Jones Corporation, who's located in Burlington, Vermont. And we have Smith Incorporated, that's located in Plattsburgh, New York. Jones Corp buys 5,000 widgets from Smith Incorporated for $100,000. Jones receives those widgets but is very unhappy with them as they keep breaking. Jones tries to resolve the issue with Smith, but Smith isn't cooperating with any sort of resolution. So Jones decides to sue Smith. The question is, which court has original jurisdiction? What do you think? If you are saying, well, that's federal court because we have two people from two different states. We have Vermont and we have New York, and hey, we're dealing with $100,000, so that's over $75,000. So this case is going to go to federal court. The question of which district federal court, the low one, whether it's going to be Vermont or whether it's going to be New York, they both may be proper, but our defendant is in New York, and that long arm statute here is going to apply. The court is going to have to, if they go to Vermont to sue, that court is going to have to determine whether or not they have jurisdiction over our New York defendant. And looking at that long arm statute minimum contacts will play a role. So Jones's best bet is to come to New York and do it in Northern District of New York. So that concludes this section. The next section, we're going to talk about specific lawsuits.